Welcome to a discussion about obligations in legal terms, a critical component of contract law and other legal transactions. While the term obligation might sound simple or mundane in everyday conversation, in the realm of law, it's a term with significant weight and intricate considerations. Now let's delve into the heart of the matter. An obligation, in the legal sense, emerges from a legal compulsion for one to do something or abstain from doing something. So if you're legally compelled to act or not to act, and you comply or fail to comply, an obligation is born. This is based on the general provisions relating to obligations as outlined in Section 493. But what exactly does this imply? Well, let's consider an example. Say, you sign a contract to purchase a house. The legal compulsion here is your agreement to pay a certain amount to the seller. If you fail to do so, you've omitted an action you're legally compelled to do, thus creating an obligation. And it's not just about creating obligations. There's also the matter of maintaining them. The obligation you've created, as in our house purchase example, must be maintained and determined pursuant to the relevant legal provisions. This essentially means that the obligation must be upheld and its implications determined according to the law. The creation and maintenance of obligations are not limited to contracts alone. They can be birthed from various circumstances such as laws, indirect or quasi-contracts, unilateral commitments, unjust enrichments, and acts treated as tort or quasi-tort under law. This intricate web of obligations forms the cornerstone of many legal transactions, from buying a house and signing an employment contract to fulfilling a promise you've legally bound yourself to. It's a fascinating, complex world that underscores the importance of every action we take or don't take in the legal sphere. As we've seen, obligations in legal terms arise from a legal compulsion to act or refrain from acting. Now, let's dive deeper into the circumstances in which obligations are created according to Section 494. Let's break down the 7 circumstances under which obligations can be created. First up, we have obligations created by law. This is pretty straightforward. If there's a law that says you have to do something or not do something, then you have an obligation to follow that law. Next, obligations can also be created by a contract. If you sign a contract agreeing to perform a certain task or provide a certain service, then you have an obligation to fulfill the terms of that contract. Moving on, we have obligations that arise from indirect or quasi-contracts. These are a little trickier to understand, but essentially they're obligations that come about not from a formal contract, but from a relationship or situation that implies a contractual obligation. Fourth, we have obligations that arise from unjust enrichment. This occurs when one party benefits at the expense of another in a way that is considered unjust. The party who has been unjustly enriched has an obligation to compensate the other party. Fifth, obligations can be created by a unilateral commitment. This is when a person voluntarily assumes an obligation, even without a contract or law requiring them to do so. Next, we have obligations that arise from an act to be treated as tort under law. A tort is a wrong that results in harm to another person, and the person who committed the tort has an obligation to make things right. Finally, we have obligations that arise from an act to be treated as a quasi-tort under law. This is similar to a tort, but it involves a harm that is not directly caused by the person who has the obligation. These 7 circumstances provide a comprehensive overview of the different ways in which obligations can be created in legal terms. Once an obligation is created, it must be fulfilled. Let's explore how this works under Section 495. At its core, obligation fulfillment is a straightforward concept. When an individual or entity has an obligation, they are responsible for carrying it out. This responsibility is not diminished by the passing of time, nor is it lessened by changes in circumstance. It is a duty that must be fulfilled, regardless of the situation. However, life is unpredictable. The person who has an obligation might not always be there to fulfill it. What happens then? Well, in the event of death or incapacity, the responsibility of fulfilling the obligation falls upon their successors. This means that the heirs who inherit the property of the obligated person are now duty-bound to fulfill the obligation. But what if the obligated person doesn't have any heirs? Or if the heirs are unable or unwilling to fulfill the obligation? This is where guarantors come into play. In a contract guarantee, A guarantor agrees to fulfill the obligation in case the original obligated party is unable to do so. It's a safety net of sorts, ensuring that the obligation is not left unfulfilled. Now, it's important to remember that the role of a guarantor is not taken lightly. They step into the shoes of the obligated person and assume their duties. They are bound by the same rules and expectations, tasked with fulfilling the obligation to the best of their ability. This is the essence of obligation fulfillment. It's a chain of responsibility that ensures obligations are met, regardless of what life throws our way. It's a testament to the seriousness with which the law views obligations. They're not mere suggestions or preferences. They're duties, binding and inescapable. So, when an obligation is created, it's not a matter of if it will be fulfilled. It's a matter of when and by whom. Because whether it's the original obligated person, their heirs, or a guarantor, someone will step up to ensure the obligation is met. Obligations, once created, must be fulfilled, even in the event of death or incapacity of the obligated person. The timing of obligation fulfillment is also crucial. Section 496 provides specific guidance on this matter. When it comes to the fulfillment of obligations, timing is everything. The law is clear. If a specific period has been stipulated for fulfilling an obligation, it is the duty of the concerned person to ensure that such an obligation is fulfilled within that period. This time-bound fulfillment is not just a suggestion, but a legal requirement. It's a rule that holds regardless of whether the obligation stems from a contract, a law, or even an indirect or quasi-contract. But what happens when an obligation is not met within the specified time? The law is unequivocal on this too. If an obligation is not fulfilled within the time frame set out in the contract or law, the person who is bound to fulfill the obligation is deemed to have failed to fulfill or to have been unable to fulfill the obligation. This can have significant legal implications, including potential penalties and the possibility of being held in breach of contract. On the other hand, if a particular day or time has been set for fulfilling any obligation, the concerned person must fulfill such obligation on that day or at that time. Interestingly though, if there's a stipulation that the obligation must be fulfilled within a certain day or time, the obligation may be fulfilled even before such day or time. But what if there's no specified period, day or time? This is where the concept of a reasonable period comes into play. The law provides that, in the absence of a specified timeline, the period, day or time for fulfilling the obligation should be determined having regard to the nature of the obligation, and the obligation must be fulfilled within a reasonable period. What constitutes a reasonable period can depend on a variety of factors, including the nature of the obligation itself and the circumstances surrounding it. As we've seen, the timing of fulfilling obligations is critical and can have significant legal implications. Finally, let's look at joint obligations, where more than one person is obligated to fulfill a commitment. Joint obligations are fascinating because they showcase how our legal system accommodates collective responsibilities. Imagine a scenario where multiple people have entered into a contract, or perhaps a law requires a group of individuals to act or refrain from acting in a certain way. This scenario brings us to the concept of joint obligations. According to Section 497, when more than one person undertakes to fulfill an obligation, or when an obligation is created in relation to multiple individuals, every person involved is responsible for the obligation's fulfillment. Now, you might ask, what does this mean in practical terms? Well, in simple words, it means that each person has a role to play in fulfilling the obligation. It's like being part of a team where everyone has a specific role to play, and the team's success depends on everyone performing their part. In the context of joint obligations, the team is the group of individuals who have the obligation, and the success is the fulfillment of that obligation. But what happens if one or more individuals fail to fulfill their part of the obligation? Well, in such a scenario, the law usually steps in to ensure that the obligation is fulfilled. It might mean that the other individuals involved have to pick up the slack, or it could result in legal consequences for those who failed to fulfill their part of the obligation. It's also worth noting that joint obligations aren't necessarily equally divided among all the individuals involved. The specifics of each person's responsibilities depend on the nature of the obligation and the terms agreed upon by the individuals involved. In conclusion, joint obligations are an integral part of our legal system. They highlight the importance of collective responsibility and demonstrate how our legal system ensures that obligations are fulfilled, regardless of the number of people involved. When multiple people are involved in an obligation, each person has a role to play in fulfilling the obligation. Let's summarize what we've learned about obligations in legal terms. We've delved into the core concept of obligations, which are created when there's a legal compulsion for one to do or abstain from an act. We've also understood that obligations can be created in various circumstances, including through laws, contracts, indirect or quasi-contracts, unjust enrichment, unilateral commitments, torts, and quasi-torts. Then we moved on to the fulfillment of obligations, emphasizing that individuals are responsible for fulfilling their own obligations. In the event of death or mental incapacity, an heir, guardian, or guarantor can step in. We also discussed the timing of obligation fulfillment. If a period is specified, the obligation must be met within that time frame. If not, it should be fulfilled within a reasonable period. Finally, we explored joint obligations, where all involved parties are responsible for fulfilling the obligation. Understanding obligations in legal terms can help in navigating complex legal transactions and contracts. Thanks for joining this discussion.